we're going to talk today about how to make decisions for adults who do not have the capacity to make decisions for themselves. And as lawyers, we get to see a lot of different things that are possible. There are a lot of horror stories that some of which I will share, and Heather will share some as we go through this presentation. But I don't want you to get paralyzed by everything that's possible. Because if you look at everything that's possible, it's easy to get overwhelmed. And I don't want this talk to make you fearful about everything that could happen. What I do want you to focus in on are the things that are likely to happen, the probable things, the things that we can reasonably expect to happen. And then, of course, there are certain things that are inevitable. Now, as an estate planning attorney, what do you think I think might be inevitable? Most people shout out death and taxes. So we can actually do most things about taxes now. The estate tax exemption is now $5.3 million per person or $10.6 million per married couple. So raise your hand if you think you might be worried about taxes. But most people don't have to worry about taxes anymore. Now, we're talking today about making decisions for an adult over the age of 18. So 18 and older is what defines an adult in Georgia. And how do we determine whether this person might need a guardian? And there are a lot of different factors that the court considers when trying to evaluate whether somebody might need a guardian. One of those factors is intellect. So intellectual capacity is one of the factors the court considers. Obviously, an IQ test of some sort is helpful in this realm, but it is not determinative. But intellectual capacity is one of the factors the court considers. A big factor the court considers, I would almost say bigger than intellect, is behaviors. How does their disability affect their ability to control themselves, act socially appropriate in various environments? So the court is looking at, what does this person actually do when they are out in the world, when they are managing their life? And then a third factor the court's looking at is what opportunities does this person have in their life? If they rarely have an opportunity to get themselves into trouble, we may not actually need a guardianship. Or if we're able to function and get things done, we may not need to do a guardianship. For instance, we'll see situations where mom is maybe 90 and their child is maybe 60, and their child with Down syndrome at 60 years old, mom has just always been doing everything for them. No one's ever questioned it. Well, the opportunity for needing a guardianship has not yet arisen because the doctors just assumed mom could make the decision. But we have this wonderful new law called HIPAA. Anybody familiar with HIPAA? It's the federal healthcare privacy law. It basically has a lot of telling doctors, hospitals, and insurance companies who you can talk to, who can make decisions. And that is one of the leading factors now of why we have to do guardianships. And that's because we're losing the opportunity to manage healthcare decisions for an individual. And so that's where the opportunities are limited. And so the court has to intervene, create a guardianship, and empower somebody to make decisions for that person. So these are just three of the areas that the court considers when determining whether a guardianship is needed.